All rise, uyugulewe. The International Residual Mechanism for Criminal Tribunals is now in session. La Jones Mécanisme international appelé à exercer la fonction residuelle de tribunaux pénaux et ouverts. Please be seated.
Good afternoon to everyone within and beyond the courtroom. Mr. Registrar, would you please call the case?
Thank you and good afternoon, Your Honours. This is case MICT-15-96. The prosecutor was Mr. Stanišić and Franco Simatović.
Thank you. And may we have the appearances, please?
Good afternoon, Mr. President. Your Honors, appearing for the prosecution today, myself, Douglas Stringer, with Grace Harbor, Dunya Ridan, and Thomas Logel.
Good afternoon, Your Honours. For Mr. Stanišić, myself, Wayne Jordash, Joe Holmes, and Mirjana Vukojnović.
Dobar dan, časni sud.
Good afternoon, Your Honors. The Simatović defense is represented by Melanie Vranješ, Vladimir Petrović, and myself, Mihailo Bakrać. Thank you.
Thank you. The trial chamber is sitting today to pronounce its judgment in the case of the prosecutor versus Jovica Stanišić and Franco Simatović. I will read a summary of the judgment, highlighting the trial chamber's key findings. The written reasons for the judgment will follow as soon as possible after the conclusion of the editorial process. This procedure is provided for in Rules 122A and C. The written judgment, when filed, will be the only authoritative version of the judgment. Before addressing the merits, I would like to express appreciation to those who have assisted us in bringing this case, which is being tried for a second time, to a close. We have received excellent support throughout this case from our court officers and reporters and the staff in language services, information technology, witness support and protection, detention, general services, and security. Your work was never easy and was made even more difficult as a result of the COVID-19 pandemic. The trial chamber thanks you. Our task in conducting this case has been benefited from the skilled and seasoned advocacy of Mr. Stringer, Ms. Harbour, Mr. Jordash, Mr. Bakrash, Mr. Petrović, and their teams. This is the last time we'll be in this courtroom together. We thank you for your professionalism, pragmatism, and collegiality, which have greatly assisted the trial chamber. As I continue to the substance of today's ruling, I request those within and without the courtroom, whose native language is one of the variants of the languages spoken in the countries that comprised the former Yugoslavia, to kindly note that I intend no disrespect if my Anglophone-trained tongue at times proves inadequate when identifying the names of persons or places. This case has a long history. The proceedings commenced before the International Criminal Tribunal for the former Yugoslavia in 2003, around 18 years ago, when the accused were indicted and transferred to the tribunal. The first trial concluded on the 30th of May 2013 with a verdict of acquittal on all counts. In December 2015, the Appeals Chamber of the International Criminal Tribunal for the former Yugoslavia quashed the acquittals and ordered a full retrial in this case. That decision started the case anew before the mechanism, necessitating a new initial appearance and a pre-trial process. In the course of the retrial, the trial chamber received the evidence of 145 witnesses, including the live testimony of 80 witnesses, and admitted into evidence more than 6,300 exhibits. It also issued nearly 450 decisions and orders. Today's pronouncement, to be followed by the filing of the written reasons, will be our last. This case concerns Jovica Stanišić, who was deputy chief and later chief of the Serbian State Security Service, and Franko Simatović, one of the service's senior intelligence officers. The prosecution has charged them with war crimes and crimes against humanity, including murder, deportation, forcible transfer, and persecution, allegedly committed by Serb forces in Croatia and Bosnia and Herzegovina between April 1991 and December 1995. In Croatia, these crimes allegedly occurred on the territory of the former Serb autonomous region of Krajina and of Slavonia, Baranja, and Western Srem. In Bosnia and Herzegovina, the indictment focuses solely on crimes allegedly committed in the municipalities of Bijeljina, Zvornik, Bosanski Samac, Doboj, and Sanski Most, and in an area near the village of Trnovo. The prosecution does not allege that the accused physically committed the war crimes and crimes against humanity charged in the indictment. Rather, it alleges that they committed them by participating in a joint criminal enterprise. In the alternative, the prosecution alleges that the accused are responsible for having planned, ordered, and or aided and abetted in the commission of the crimes. At the outset, the trial chamber notes that it was presented with extensive evidence on the historical context and political developments forming the backdrop of the conflict that enveloped the former Yugoslavia from 1990 through 1995. While it has thoroughly considered such evidence, the trial chamber does not see it as its task in writing the definitive history of the dissolution of the Socialist Federal Republic of Yugoslavia, identifying the historical scars, defining the complex political and socio-economic reasons, the turbulent processes of political transformation, the diverging political agendas, and people's hopes and aspirations that accompany the dissolution of a state must be left to historians. The task before this trial chamber is very specific. It is to ascertain whether the accused incur individual criminal responsibility for the crimes of murder, deportation, forcible transfer, and persecution as charged in the indictment. A state of armed conflict existed during the time relevant to the crimes charged in the indictment. The evidence presented at trial also amply demonstrates that during this period, there was a widespread and systematic attack directed against the non-Serb civilian population in the areas of Croatia and Bosnia and Herzegovina relevant to the indictment. Starting with the attack on the village of Kijevo in August 1991, in the Serb autonomous region of Krajina, a clear pattern emerges of crimes and acts of violence committed by Serb forces, including members of the Yugoslav People's Army and units of the Militia Krajina and Territorial Defense in Croat-majority villages in Krajina. These attacks resulted in the mass exodus of the majority of non-Serb inhabitants from the area. Croat property was looted, homes were torched, churches and schools were destroyed, and Croat civilians were mistreated, arbitrarily detained, beaten, expelled, or killed. Villages were razed to the ground and emptied of their Croat residents. The judgment contains detailed findings on the brutal killings of non-Serb civilians and on other crimes and acts of violence committed by Serb forces between October and December 1991 in the area of Hrvatska Kostajanica, including near the village of Bacin, and in the villages of Vukovici, Poljanak, Lipovaca, Saborsko, Skarbanja, and Bruska. In parallel, attacks on Croat-majority villages in the Serb autonomous regions of Slavonia, Baranja, and Western Srem intensified in August 1991 with the takeover of towns and villages in the area by Serb forces. These forces included the Yugoslav People's Army, local territorial defense, local police, and paramilitary groups, such as Arkan's Serbian Volunteer Guard. Following the attacks, an atmosphere of terror reigned through Croat-majority settlements. Local non-Serbs were subjected to harassment, mistreatment, arbitrary detentions, and forced labor, and their property and religious buildings were looted and torched. The judgment contains detailed findings of the brutal killings by Arkan's band and other Serb forces of non-Serb civilians detained at the Dai police station and at the Erda trading camp in the period between September and December 1991. Following the violent takeover of towns and villages in the area, non-Serbs were forcibly expelled or left with no choice but to flee from the ensuing violence. Turning to Bosnia and Herzegovina, a similar pattern of crimes ensued from the beginning of April 1992, following the violent takeover by Serb forces, including the Yugoslav People's Army and paramilitary units of towns and villages in the municipalities of Bijeljina, Zvornak, Bosanski Samac, Doboj, and Sanski Most. Civilians, primarily Bosnian Muslims and Bosnian Croats, were killed, beaten, and otherwise mistreated, arbitrarily arrested and detained, tortured, and subjected to forced labor and sexual violence. Their property was looted and torched, and their religious monuments destroyed. In Bijeljina, which was the first municipality to be taken over by Serb forces in April 1992, a reign of terror was instituted by paramilitary groups such as Arkan's Serbian Volunteer Guard, the White Eagles, and Mauser's Serbian National Guard, together with members of the local police. These groups engage in criminal activities on a massive scale, terrorizing the non-Serb residents as well as Serbs considered to be disloyal by looting, committing murders and rapes, and arbitrarily detaining and mistreating non-Serbs in various detention facilities in the municipality. In the coming months, mass movements of Bosnian Muslims leaving the municipality due to the campaign of terror, violence, and mistreatment took place. In the course and immediate aftermath of the attacks on Zvornik in April 1992, Serb forces, including paramilitary groups such as Arkan's Serbian Volunteer Guard, Šešel's Men, Yellow Wasps, and local Bosnian authorities, killed and forcibly expelled local non-Serb residents from the municipality. Detention facilities in Zvornik municipalities were established, where many non-Serbs were kept in deplorable conditions, beaten, mistreated, tortured, and killed. Crimes and acts of violence forced the majority of the Bosnian Muslim population to leave the municipality. This pattern of crimes was replicated in Bosanski Samac, following the takeover of the municipality by Serb forces, including paramilitary groups, in April 1992. Numerous crimes were committed against the non-Serb population through the municipality, including looting, rape, and the destruction of religious buildings and cultural monuments. Serb forces arbitrarily detained Bosnian Muslims and Bosnian Croats in at least 6 detention facilities throughout Bosanski Samac, where detainees were kept in inhumane conditions and were subjected to forced labor, severe mistreatment, repeated beatings and torture, forced to engage in sexual acts, and killed. On or about the 7th of May 1992, in the detention facility located in the village of Starkovina, 16 Muslim and Bosnian Croat men were killed. The crimes and acts of violence committed by Serb forces during and following the takeover of Bosanski Samac forced the majority of the non-Serb population to leave the municipality. The pattern of crimes continued with the takeover by Serb forces, including paramilitary groups of Doboj, in May 1992. Non-Serb residents were harassed, their houses were looted, and religious monuments demolished. Numerous detention facilities sprang across the municipality, where Bosnian Muslim and Bosnian Croat civilians were kept in appalling conditions, severely mistreated, beaten, used to perform forced labor, tortured, and killed. On the 12th of July 1992, members of the Serb forces killed 16 non-Serb civilians by using them as human shields. The living conditions and the numerous crimes and acts of violence targeting the Bosnian Muslim and Bosnian Croat residents of Doboj forced the majority of them to leave the municipality. Following the takeover by Serb forces of Sanski Most in May 1992, a campaign of terror was unleashed against the non-Serb residents of the municipality. Homes and religious monuments were destroyed, and Bosnian Muslim civilians expelled or killed. Discriminatory policies were put in place, and local Bosnian Muslims and Bosnian Croats were arbitrarily arrested, mistreated, and detained in deplorable conditions. In September 1995, Arkan's Serbian Volunteer Guard killed a large number of non-Serb civilians at Trnava and Sasina. In July 1995, during the Treskavica-Trnovo operations, 6 Muslim men and boys were killed by the paramilitary group Scorpions. The trial chamber finds that, in relation to the events described above, the prosecution has proven beyond a reasonable doubt the allegations of murder as a crime against humanity and a violation of the laws or customs of war charged in the counts 2 and 3 of the indictment. Having considered the circumstances surrounding the departure of the non-Serb civilians from the areas in Croatia and Bosnia and Herzegovina relevant to the indictment, the trial chamber also finds that all the elements of deportation and other humane acts, forcible transfer as crimes against humanity, charged under counts 4 and 5 of the indictment have been satisfied. The trial chamber further finds that the murders and forcible displacements were carried out with discriminatory intent and thus satisfy the elements of persecution as a crime against humanity charged under count 1 of the indictment. The trial chamber considers that the systematic pattern of crimes committed against non-Serb civilians by Serb forces constitutes the most compelling evidence demonstrating the existence of a common criminal purpose. For the reasons stated in the judgment, the trial chamber is convinced that from at least August 1991, a joint criminal enterprise existed. The common criminal purpose of this enterprise was to forcibly and permanently remove the majority of non-Serbs from the above-mentioned areas through the commission of the crimes charged in the indictment. This common criminal purpose was shared by certain senior political, military, and police leadership in Serbia, in the Serb autonomous regions of Krajina and Slavonia, Baranja, and Western Srem, and in the Serb Republic of Bosnia and Herzegovina, which was later renamed Republika Srpska. The trial chamber now turns to the question of whether the accused participated in this joint criminal enterprise and shared its members' intent. The indictment alleges that the accused participated in the joint criminal enterprise by providing channels of communication between and among the core members of the joint criminal enterprise in Belgrade and locally, and by directing and organizing the formation of and the financing, training, logistical support, and other substantial assistance or support to various Serb forces, including special units of the Serbian State Security Service, which were involved in the commission of the crimes described above. In relation to the Serb forces in the Serb autonomous region of Krajina, as explained in the written judgment, the trial chamber finds that both accused were involved in providing some form of assistance in the first half of 1991 to local security structures, including assistance in relation to the training of members of the Krajina Police, Krajina Territorial Defense, and other volunteers of the Golubic camp, and subsequently at the Knin Fortress. The prosecution, however, did not prove beyond reasonable doubt that the common criminal purpose existed before August 1991. Accordingly, the trial chamber is not satisfied that through this conduct, the accused contributed to the furtherance of the common criminal purpose. The trial chamber has reached a similar conclusion with respect to any contribution the accused may have made in relation to Serb authorities and forces in the Serb autonomous region of Slavonia, Baranja, and Western Srem. In relation to the Serb forces in Bosnia and Herzegovina, the trial chamber considers that Stanišić was in frequent contact with Radovan Karadzic before and after the formation of the Bosnian Serb Republic. However, there is not sufficient reliable evidence demonstrating beyond a reasonable doubt the nature and type of any specific assistance that the accused may have provided to Karadzic or to other alleged members of the joint criminal enterprise in relation to the establishment of a separate Serb police and military structures in Bosnia and Herzegovina. For the reasons articulated in the judgment, the trial chamber further finds that the prosecution has failed to prove beyond reasonable doubt that the accused contributed to the furtherance of the common criminal purpose by directing and organizing the formation, financing, training, logistical support, and the provision of other substantial assistance or support to paramilitary units, including the Serbian Volunteer Guard headed by Arkan, or to the Scorpions, in connection with the commission of the charged crimes. Turning to the Serbian State Security Special Units, the prosecutor alleges that Stanišić and Simatović had authority of these units, commonly known as Frankie's Men or Red Berets, in short, the unit, and used the unit to commit crimes that advance the common criminal purpose. The prosecution submits that the accused established the unit on the 4th of May 1991, and that under both accused control, with Simatović as its commander, the unit existed continuously throughout the indictment period and its members committed crimes. The trial chamber is convinced that the accused participated in the formation of and directed a special purpose unit under the authority of the Serbian State Security Service. This formation began in the summer of 1991 with the training of recruits at the Golubic training camp near Kanin. At least around August or September 1991, Simatović selected around 28 of the best trainees and trainers to form a specialized unit that would operate secretly under the Serbian State Security Service. These unit members were taken to Belgrade and then to the Lezimir camp in Fruška Gora, Serbia, and the Pajos camp in Ilok, Croatia, where they continued to train together and to train others through the first part of 1992. However, the prosecution has not proven beyond reasonable doubt that unit members or those trained by them participated in crimes in Croatia that can be attributed to the accused. With respect to the crimes committed in Bosnia and Herzegovina, the trial chamber finds that in March 1992, unit members trained a group of around 18 men from Bosanski Samac. Another group, including former special police officers, namely Streko Radonovanovic, also known as Debeli, and Slobodan Milkovic, also known as Lugar, were also trained in this period and were absorbed into the unit. The trial chamber finds that on the 11th of April 1992, unit members including Debeli, Lugar, and Dragan Djordjevic, also known as Strani, flew from Pajos by army helicopter to village near Bosanski Samac. These unit members and others were accompanied by a group of Bosanski Samac locals. On arrival, the group was resubordinated to the Yugoslav People's Army and took orders from the area commander. As discussed in the judgment, these men also participate in the commission of crimes charged in indictment in relation to Bosanski Samac. The evidence is not sufficient, however, to establish that the accused had authority over them or otherwise instructed and supported them during the commission of the crimes. Nevertheless, the trial chamber considers that the accused provided practical assistance which had a substantial effect on the commission of the crimes in Bosanski Samac. By training and deploying unit members and local souls from Bosanski Samac to participate in the takeover of the municipality. For the reasons explained in the judgment, the prosecution has not proven beyond reasonable doubt that, other than in relation to Bosanski Samac, the accused contributed to or provided practical assistance to the commission of crimes charged in the indictment through special purpose units of the Serbian State Security Service. In relation to the accused's intent, the trial chamber finds that Stanišić had a comprehensive knowledge of the events on the ground in Croatia and Bosnia and Herzegovina during the indictment period. The trial chamber finds that Simatović also had unimpeded access to information and about the events on the ground, one of his primary tasks during the indictment period being the collection of intelligence. Having considered the totality of the evidence before it, and in view of the scale and pattern of crimes that occurred during and in the aftermath of operations by Serb forces in the areas covered by the indictment, the trial chamber finds proved beyond reasonable doubt that both accused were aware of the campaign of murder, persecution, and forcible displacement targeting non-Serbs in Croatia and Bosnia and Herzegovina during the indictment period. When considered in the context of the accused interactions and their extensive and detailed knowledge of the events unfolding on the ground during the indictment period, the only reasonable inference from the evidence is that the accused were also aware of the shared intent of the members of the joint criminal enterprise to forcibly and permanently remove the majority of non-Serbs from large areas of Croatia and Bosnia and Herzegovina through the commission of crimes charged in indictment. The trial chamber may infer the existence of a particular fact upon which the guilt of the accused depends from circumstantial evidence. However, it must be the only reasonable conclusion that could be drawn from the evidence presented. If there is another conclusion, which is also reasonably open from the evidence, the conclusion of guilt beyond reasonable doubt cannot be drawn. Having considered the entire evidence before it, the trial chamber does not find that the only reasonable inference from the evidence is that Stanišić and Simatović shared the intent to further the common criminal purpose. Accordingly, for the reasons explained in the judgment, the prosecution has not proven beyond reasonable doubt that the accused participated in a joint criminal enterprise. Nonetheless, the trial chamber is satisfied that the accused provided practical assistance which had a substantial effect on the commission of the crimes of murder, forcible displacement, and persecution committed in Bosanski Samac, and were aware that their acts assisted in their commission. Accordingly, the trial chamber finds them criminally responsible for aiding and abetting the commission of the crimes in Bosanski Samac. The trial chamber does not find the accused responsible for planning, ordering, or aiding and abetting any other charged crime. For the foregoing reasons and for reasons explained in the judgment, the trial chamber finds Jovica Stanišić and Franko Simatović responsible for aiding and abetting under Article 7.1 of the ICTY statute the crimes of murder, deportation, forcible transfer, and persecution committed in Bosanski Samac. The trial chamber therefore finds Jovica Stanišić and Franko Simatović guilty of counts 1 to 5 of the indictment. Having considered all relevant factors, the trial chamber sentences Jovica Stanišić to a single sentence of 12 years of imprisonment and Franko Simatović to a single sentence of 12 years of imprisonment. In accordance with Rule 125C, Mr. Stanišić and Mr. Simatović are entitled to credit for the period of time they have been detained in custody pending surrender to the ICTY during the original trial and appeal proceedings and during the retrial. Pursuant to Rule 127C, Mr. Stanišić and Mr. Simatović shall remain in the custody of the mechanism pending the finalization of arrangements for their transfer to the states where they shall serve their sentences. The trial of the prosecutor against Jovica Stanišić and Franko Simatović has come to a close. The written reasons for the judgment will be filed as soon as possible. And with that, the court stands adjourned.
All rise. Veuillez vous lever.